Here he comes. Okay, let's get started with this afternoon's agenda. The next item is item 9A, enforcement.
Okay, while we're waiting on our enforcement chief, can I make a few announcements? Madam
Yes.
President? Oh, good. Okay, so board members were handed out the emergency information form. If you could try to complete that by today and hand that over. We keep this on file and we bring this with us in the event that we have an emergency, and all of you know in the past we have had emergencies at our board meetings that we'll know who to call. So it's important that you try and fill that out as best as you can. Secondly, I don't know if other people at the dais were having trouble hearing, but according to our webcast and the audience, they could hear our members when they spoke, but the members couldn't hear themselves speak, so to speak. So if you could pull the mic close to you, then all of you at the dais will also be able to hear the conversation, and it will be projected outside to the audience and on the webcast. So just make sure to pull those microphones real close to you. Okay?
Okay. I want to take this a little out of order. If Ms. Snyder is ready, we will go there first. And that's item 9B. This is Linda K.
Sorry, we didn't give you enough time to sort of.
Sorry. The Senior Assistant Attorney General in the Licensing Division. Thank you.
Thank you very much. Let's see. It's on. Okay. Can you hear me?
Yes.
Thank you. It's a pleasure to be here this afternoon. I appeared last time about the same time of year to discuss the Attorney General's first annual report on the prosecution of accusation cases on behalf of the board. So the executive officer, Ms. Fisher, invited me back again this year to talk about the second annual report and to provide you with some comparisons between year one and year two. I did bring along with me, and if this is okay to distribute to the board members and any interested public members. Thank you. This is the handout I've provided is a snapshot of what's provided in the annual report with respect to the dental board's accusation cases. So that's a summary. The full report looks like this, similar to last year. It's quite thick. It includes one page for each of our client agencies that we represent between the licensing section and the health quality enforcement section. So the handout I'm providing is the page of the report that is for the dental board specifically. I hope you'll have an opportunity to read the introductory portions of the report and peruse through the other agencies as well at some point. And it is posted on the Attorney General's website, so you'll be able to find the full report there. Or if anybody is ever interested, ask me and I'd be happy to send you a copy. But one of the reasons I point out the introductory sections is because we made some changes this year in comparison to last year with respect to how the data is put together and presented. So I wanted to point those out to you. First of all, there's two main sections of the report. One is Subdivision A, which is the counts of various matters that are required to be reported by the legislation, Business and Professions Code Section 312.2. The second part is Subdivision B, which are averages, average amount of time from one event to another. So some of the changes we made to ensure that we had complete consistency between the licensing section and the health quality enforcement section on exactly what we were reporting were as follows. Number one, for Subdivision A1, the request is to report the number of accusation referrals. And so last year, we reported the number of accusation referrals for the licensing section by respondent. In other words, if a dentist was referred to our office for disciplinary action, we would count that dentist as one respondent and one referral. We found this was inconsistent with our sister section, the Health Quality Enforcement section, who reported each investigation referred. So in other words, if one respondent had 3 investigations, 3 consumer complaints, each of which were investigated and referred to our office, the licensing section would have reported that as 1, whereas the Health Quality Enforcement section would have reported it as 3. So we wanted to make sure we're completely consistent, and so we are now reporting our referrals by investigation as opposed to by individual respondent. So that's one of the differences. A second difference is under Subdivision A5, which requests information about the number of accusations filed. Similarly, with respect to health quality enforcement and licensing, we had a division last year that, frankly, we weren't even aware of. Licensing reported only on initial accusations filed, and health quality enforcement reported accusations and amended accusations filed. So again, we had to get on the same page, and so this year we've reported the total, which is both accusations that are initial and amended. And then the third is on Subdivision A7 Adjudications. We report every adjudication under Subdivision A7, which asks for, how many accusations are adjudicated. Adjudication, to refresh, means when the work of the Attorney General's office is done to be able to get the case to the point where it is returned to the board for the board to make its decision. So there's certain events that bring the case back before the board to make its decision. One being a default if the respondent doesn't file a notice of defense or fails to appear at hearing. Number 2, a stipulated settlement. Number 3, the case being submitted to an administrative law judge at hearing. And number 4, if the accusation should be withdrawn. So those are the adjudicative events that will then bring the case back before the board for the board to make a decision. So under A7, we've reported all adjudicative events, and it's a small distinction because sometimes a case will have more than one. For example, if a respondent should default on a case, but then the board sets aside the default and allows them to file a notice of defense and proceed, that would end up with 2 adjudications because ultimately the case would resolve in a manner other than the default. So that's an example. So those are just preliminary. Then getting to the board's page of the report and walking through it, comparing information from last year to this year, I can share these observations with you. So with respect to Subdivision A1, as I mentioned, we've had a change in the manner in which it's reported. So it's reported that we received 110 accusation referrals. If we reported it exactly the same as last year by just respondent instead of investigation, it would have been 92. But because there were multiple investigations for some respondents, the number reported is 110. Last year, the number of accusation referrals was 83. So we've gone up by 11% with respect to the number of referrals that we received from the board in this fiscal year. I think I forgot to mention that the time period we're talking about is fiscal year 17-18. The report was published January 1st of 2019, but it's based upon the data for that fiscal year 17-18. Okay? And the prior report I refer to is for the previous fiscal year, which would have been 2016-17. Then the number of accusation matters rejected for filing by the Attorney General in this fiscal year, the second reporting period, there were 4 matters that were rejected, and in the previous year there were none. That's, I think, just a matter of happenstance. You know, what comes to our office, we review each case to determine if there's clear and convincing evidence to bring charges against a respondent. And if so, we'll proceed to file, but if that burden can't be met, we'll reject the case. Then Subdivision A3, matters for which further investigation was requested, and then the companion to that is Subdivision A4, the number of investigations received. I think in this area we saw some really good progress between the 2 years. In the prior fiscal year, 16-17, there were 12 requests for further investigation by our office of the dental board's investigators. And in the second fiscal year, there were only 5. Correspondingly, there were 10 requests for, investigations received in the prior year, and in the second year, only 5. So what this means to me is that the investigations that are coming from our office, from the board, are more complete, and it's a more rare case where we have to follow up with board investigators to obtain further investigation. So I commend the board's investigators in that regard, because that means the cases will move more quickly when the investigations are complete from the beginning. Then under number 5, that's the number of accusations filed, and including both the initial and amended accusations, there were 86 this year. That's down from 93 the previous year. And of the 86, 79 of them were initial accusations and 7 of them were amended. So the rate of filing accusations was down by about 9%. The number of accusations withdrawn this year was 3, and in the previous year it was 6. An accusation withdrawn means it's been filed, but something has happened during the litigation process to make the prosecutor or the complainant believe that we should not pursue the case. Oftentimes it's as a result of discovery. During that discovery process, we learn more about the case from the opposing party. Or the other instance that causes a withdrawal of an accusation is when the respondent dies, and then the accusation would be withdrawn. So that's down 50% from the prior year. And then the number of accusations adjudicated this year was 76, and in the prior year was 113. So that's down by about 33%. Fewer adjudications in the second fiscal year. Then turning to the second part of the table on this page is the information under Subdivision B of 312.2. And that's what I call the averages part of the report. In this part, under subdivision number 1, it speaks to the amount of time it takes from the time an accusation referral is received in the Office of the Attorney General until the time the accusation is filed. So the tasks that are required to get to that stage include review of the investigation by the prosecutor, drafting the accusation, of course, determining that there is, in fact, sufficient evidence to go forward. And then once the accusation is drafted, it's sent to the board staff reviews it, the executive officer reviews it, and then ultimately the executive officer signs the accusation, which is the date of filing of the accusation. So the amount of time it has taken on average to get to that point in time where the board's accusations were filed in this second reporting year was 131 days. We also include in this averages section of the report the median and standard deviation, as well as the count of matters upon which these averages are calculated. That provides you with more context for the numbers. For example, if you have a case where it is a real outlier, it takes a long, long time for some reason or another, it can skew the mean being what we typically consider the average, but you would see perhaps a lower median because the median is the central value in an ordered set of data. And so we provide these other numbers to be able to provide more context for the quote-unquote averages. And the standard deviation, I swear I'm no mathematician, but as I understand it, the standard deviation explains how widespread your data set is. So the lower your standard deviation is, the more concentrated your data is. And the higher the standard deviation, the more widespread the data. I hope I got that right. So anyway, we provide these numbers for your information to give you as much information about your work as we can. So then comparing that average or mean number of 131 days to the previous year average was 153. So filing accusations was reduced by 14% in the second year compared to the first. The second part of Subdivision B is the amount of time it takes to file an accusation, but this is for the cases that required further investigation. So that subset of cases where the accusations are filed generally take longer because the deputy reviews the case, determines further investigation is needed, and then makes that request to the dental board investigator. The investigation is conducted, another report is generally prepared, and then sent back to the Attorney General's office. We hold the case open during that entire period, and then once that further investigation is received, we're in a position to be able to prepare the accusation for filing. So in the second year, per this report, it took an average of 153 days to file the accusations for that set of cases. There were only 5 that required the further investigation, compared to the year before, where that average was 228 days. And so we reduced the amount of time in that parameter by 33%. In order to get any case off the ground, you have to file the pleading. So this filing the pleading is always an important consideration for us when we're looking at the timeline. We want to get that done as quickly as we can so we can begin the case and get it moving forward. So both of those parameters coming down by 14% for overall filing of the pleadings and by 33% for the cases where further investigation was required is very good. So I'm very pleased to see that. Then number 3, under Subdivision B, asks about the average amount of time it takes to settle cases. So if cases are settled, how much time did it take from the time of the from the time of the filing of the accusation until the stipulated settlement occurs? This year, it took an average of 300 days, and that was based upon 47 cases that were settled. Compared to the previous year, the average was 363 days, and 80 cases were settled the previous year. So the average amount of time that it took for the settled cases was reduced by 17% in the second year compared to the first. Again, that's great. The next one is a parameter, one of the only parameters in terms of averages that went up. So that's number 4, and that's the average amount of time from the filing of the accusation to taking a default. There were 12 cases that resulted in default as reported here, and it took an average of 149 days for that batch. In the previous year, there were 13 cases, so a similar number, but the average time previously was 116 days. So in that parameter, we actually went up by 33 days, and that's an increase of 28%. So that's something we'll want to look at our office and try to bring that down. Then number 5 concerns the amount of time it takes from the time the accusation is filed until the Attorney General requests a hearing date on the case. This year it was 148 days on average for 24 cases that were set for hearing. And in the previous year, it was 182 days. So we decreased that parameter by 19%. So that's good. Then the last one is Subdivision 6, the measuring the amount of time it takes on average from the Attorney General's receipt of a hearing date until the hearing actually commences. This year it was 134 days, and last year it was 295 days. So that one is a significant decrease of 55%. And you know, when you add all these different averages together, what you're talking about really is average case processing time overall. And so when the averages go down in these various parameters, that means the board's work is getting done more efficiently and more quickly. And that's, of course, important to protect consumers. The sooner we can impose discipline against somebody who deserves it, the more we can protect consumers by preventing that perhaps negligent or incompetent dentist from continuing to practice. So if you have any questions, I'd be happy to take them.
I'd just like to say congratulations. I mean, this is good news. I would be curious to find out why that outlier is there, the amount of time between the default and, you know, getting that out. That's kind of curious, but this is awesome. So congratulations. Overall, though, with your methodology changing, really it's only going to be reflected in the first table and not so much in the second table. Is that correct?
That is correct. That is correct. So that's a good observation. And I'd also like to thank you, Ms. Fisher, and the board staff for working with us so collaboratively. This is not just our effort, it's our collaborative effort to work hard to be as efficient as we can to do the board's work and impose discipline where it's required. So thank you.
Question. Have you been able to identify any factors that have contributed to the decrease in the mean time for resolution of these issues? I mean, if we've improved by a significant percentage as far as the mean time, have you identified factors that have contributed to that?
Well, I think the answer to that is the devil is in the details. So when you go through each of these different parameters, we focus our efforts to try to do the work in all these different parameters as quickly as we possibly can. So the devil is in the details, because when we can see a manner in which we can manage something more effectively and efficiently, that's what we do. So one of the strategies we've undertaken over the last about the last year or so is trying to focus our work with each agency in the hands of fewer deputies. So to give you the broader picture, the licensing section represents approximately 30 different Department of Consumer Affairs agencies, big and small, all kinds of different subject matters. And so one of the things we find is that if we can concentrate the knowledge a bit with fewer deputies so that they're more experienced and they know what they're doing and they know, dentistry, for example, for this agency, that's an efficiency. We always have to balance that, though, in terms of making sure we have enough people that know how to do the work, and also to give opportunities for our staff to be able to do work that they consider to be very rewarding, and the dental board's work is that. So, it's always a balance of factors like that, but where we can find an efficiency, we'll go for it.
Thank you.
I was just going to say, this wouldn't reflect any of the cite and fines, because I know we're doing more of those. So these numbers might go down a little bit in terms of case volume, but we may be addressing those through other avenues.
That's a good observation as well, because this report only focuses on the accusation cases, which we also include in those numbers any accusations combined with petition to revoke probation cases, and there's usually a few of those. But you're right that it doesn't include cite and fine, it doesn't include statement of issues, it wouldn't include when we go to court on a Penal Code Section 23 appearance in a criminal case, anything like that. It's just very focused on the core disciplinary work of the board.
And when Mr. Snyder was talking about changing the methodology based on what the Health Quality Enforcement section was doing, that's essentially the medical board.
Yes. The Health Quality Enforcement section represents about 8 or 9 of the agencies that are reported in the report, but that is correct. The medical board is their core work that's their main client. Okay, well, thank you again for the invitation to be here, and I hope to come back again next year and give you another update.
Thank you so much.
Thank you.
So now we're going back to item 9A, enforcement statistics and trends.
Good afternoon, board members. Carlos Alvarez, Enforcement Chief with the Dental Board of California. I'm here to present the statistics for the second quarter, October 1st, 2018, December 31st, 2018. And I'll start off with the complaints and compliance. For the second quarter, complaints received was 1,055. And this was increased approximately by 104 cases from the last quarter. So the monthly average complaints received with the dental board approximately is about 352 complaints that we've been receiving. And the complaint cases that are currently open right now, it's 1,107. And this has decreased. The last quarter, we were at 1,279. So it was reduced by 172 cases. And I kind of want to owe this that it's been reduced is because this second quarter, October 1st of 2018 and December 31st, 2018, and that's when we started the whole process of looking into the complaint compliance procedures. And so that's when we started this, and so we're kind of seeing now the works of this, how it's decreasing now with the process that we're identifying because we want to streamline it. So I kind of owe it to this, how we started this back in the second quarter. And so currently right now, the second quarter, the average caseload for consumer service analysts is 221 cases. And again, last quarter was 277. So like I said, so we're being reduced, and the complaint compliance unit analysts are seeing less cases. So that kind of relieves the stress right there for everybody as well. So complaints closed, it's 885 cases that have been closed. And the average caseload per month was 295. So it took an average of 246 days to close, which is approximately 55 days faster than the previous quarter. And I kind of want to add this also to the dental consultants because, like I said, we've been sending out an increase of cases to be reviewed by them. So they actually been getting back these cases back to us for closures. So I want to owe that also to the dental consultants because they've been really working really fast on this to help us out with the streamline of the process in CCU. So currently right now, the investigations cases that are open currently right now with the enforcement is 850 cases. And currently we have 76 open inspection cases. And that's between Southern and Northern California. So we have closed 333 cases during the quarter two. So the average cases closed per month has been about 111 per month. And so that's the number of cases closed, filed with the Attorney General's office or filed with the District Attorney office. We filed 33 cases with the Attorney General's office for the second quarter. And I just wanted to drop down to the average number of days to complete an investigation for the second quarter. It kind of shows 573 days, and it shows that's 154 days slower than the previous quarter. But as you look, we've been really working on the cases of 3 years plus, and that's because our statute of limitations is 3 years, so we've been focusing on those cases. So as the investigation cycle time starts, as we received it, it starts counting the days as it's moving through the process. So it counts the days as it goes through the complaint compliance unit, as it moves either to the investigative analysis unit or it goes into enforcement unit, and it's counting all the days. So what we started doing, we started focusing on the 3 years because of statute of limitations, and so that we decreased that by 46%. So when it says the days were slower, it kind of just reflects how long those cases have been counting. So actually we decreased it, but the number of days it shows it's slower. But I hate to, I know it's on there, it says slower, but I don't like that word because, like I said, we made a significant decrease on the 3 years of cases that we have. So currently right now for the administrative and disciplinary actions, we have 49 citations that we issued for the second quarter, and that was an increase of 11 from the previous quarter. So we've been sitting down again with the extra reports. We sit down with our dental consultants reports, and I sit down with Karen, and we kind of determine, okay, what cases need to go to the Attorney General's office, and what cases can we identify that could go to a citation, and also identify by an order of abatement, because we could correct all the issues with an order of abatement by sending the licensee to training. So we could correct that and just concentrate on the more egregious cases and send that to the Attorney General's office. So for the last quarter, we had 21 accusations that were sent. And so, like I mentioned, we have 33 cases that were referred to the Attorney General's office. So currently, right now, we have 147 pending cases as of this December 31st of 2018. And currently, right now, we have 161 open probation cases. That means the total of licensees on probation. And again, that's a combination of licensees on probation in Northern California and Southern California. So currently right now, it's a 3-month average for a disciplinary case to be completed. It's 824 days. So it's 36 days faster. And this is another item here that we've been working on, and we show improvements because back in 17-18, we're at 1,000 days. And so then 18-19, the first quarter, we're in the 900 days. So now in the second quarter, we're at 824 days. So we've been really, and that's with the work with the Attorney General's office as well, that they've been helping us to reduce these days because DCA's performance measures are at 540 days. So we've really been making strides to reduce this. And I said we're actually on the right road right here at 824 days. And so the other things that we have monthly discipline coordination unit meetings. And as we found out that some of the cases from different offices have been sent to different offices to be handled. So I think that's attributed to this because now the Attorney General's office noticed that some of these cases were taking long, so they started sending that to different offices.
Carlos, are the
Yes.
161 open probation cases, do they include the tollers?
That includes the tollers. I'm sorry.
Okay,
I
in the
apologize.
future, let's break that out.
Yes. And I apologize. Yes, that includes the licensees who are tolling, who are in a different state or they're not practicing. So we have them on tolling. So that kind of concludes my report. If anybody has any questions.
You talked about the 3-year statute
Yes.
of limitation. Talk a little bit about that in terms of who falls within that. If you, for instance, have a case where the respondent is filing amendments, does that stop the clock?
No, so the 3-year statute of limitations, the clock starts when we actually receive the complaint at the complaint compliance unit. So that's when the clock starts. So when we receive it, that's the first date that it starts, and we have 3 years to investigate that. So now if we have, like I said, a complaint coming in and they keep sending us documents, the clock doesn't stop. It still continues on. So with criminal cases, when we receive criminal cases, actually with fraud, the statute of limitations actually extend out, and it gives us a 7-year period on that. But usually it's 3 years, or sometimes when it comes in, it's either and or. If we receive a complaint and the treatment falls down 7 years, so let's just say they complained, they said that the treatment was in 2012 or 2013, then we have they had statute of limitations 7 years, so we have to go by, okay, when was the treatment date started? And that might account for the statute of limitations to expire because it goes by the treatment date. So either it's when the treatment was provided or when we receive notification.
Any other questions? Thank you.
Well, thank you very much.
I just wanted to comment that, as you were giving your report, that the AG was talking about 110 cases that they had, and we start off with 1,000. So I like that visual so that people have some concept of what the unit does, what the unit has to handle.
Yes, it's like it's a lot of cases that we come in, and like I said, we're working on this because what we do is we have the case audits. So we identify, like I said, and I talked about this before, the case audits, we kind of identify staff's strengths, weaknesses. We start reprioritizing the cases, and so we help them along to identify that, because a lot of times they get focused just on one case that they kind of lose, that they have other cases sitting there. So we have to refocus them and reprioritize all the cases. And so that's coming along, working how we're reducing these cases and working faster by having these case audits.
And then the last thing that I wanted to mention, particularly for newer members, if it's a criminal case, we don't do that at the same time. The criminal case takes precedence.
What we've been doing now is once we complete a criminal investigation, we'll send that to the DA's office, and then we're automatically sending the accusation to the Attorney General's office, because a lot of times they're kind of waiting on the conviction. And so depending on the type of crime, if it's a serious felony, we're not going to get a conviction until 2 years, 3 years, or sometimes maybe 7 years later. And so therefore, instead of losing that case on the statute of limitations, we send it at the same time to the Attorney General's office. And then we have the Attorney General's office work with the District Attorney's office to work on that conviction there, so we don't lose the case on statute of limitations. So at first, we used to send just the case to the criminal. We used to just wait for the conviction, but we decided to send that to the Attorney General's office now at the same time.
Which means we're moving forward with administrative action as opposed to criminal action. I wanted to jump in at this point and talk about our numbers. I'm excited to see how the numbers come down within the next couple of months, and certainly by the end of this year, because a lot of our backlog has been at the beginning in our complaint and compliance unit. And I'd like to just say, as I said last meeting, we were starting the process of doing an audit of the unit, and we are going to work our way around all the units of the board to determine processes. And we are lucky enough to have 2 managers who have taken this on in addition to their duties. Tina Valerie is one of them, and Bernie Baba is our licensing manager. They have jumped in to review the complaint and compliance unit and are working closely with the manager of that unit, Crystal Williams. We've totally switched up the processes by which the information comes in and is processed. So we're hoping that by doing this, and let me just say it's been a huge change, and it's been difficult to get people to change on how work is not only assigned, but what the expectation is for the work to be completed. But I feel that we're going to have a huge success in this area, and I'm expecting to see our numbers come down significantly closer to what the department's goal is of the 500 days as opposed to where we are upwards of 500. So stay tuned. We will give you updates on that. Our plan is, after we go out of the complaint and compliance unit, we're going to shift around and do the audit of the investigative unit. We'll go into the sworn and the discipline coordinators too. So rather than go out to an outside source to do that, we're utilizing the talent we have within the board to be able to get that done. So I'm very optimistic.
Thank you.
All right, thank you.
And now we're going into the pending regulatory packet, item 10A.
Good afternoon, Sarah Wallace, Assistant Executive Officer. Quick update on several pending regulatory packages. Michael Chen, our Legislative and Regulatory Analyst, has been very busy working with Spencer to try to get all of these regulatory packages out, and so we can initiate the rulemaking. The rulemakings that are within Agenda Item 10A are regulatory packages that the board has previously approved. The next step is typically staff have to develop the initial statement of reasons, the notice of proposed text, and a fiscal and economic impact statement. And so that requires a lot of back and forth with legal counsel to make sure that we've met all of the requirements of the Administrative Procedure Act. And once legal counsel signs off, we then file it with the Department of Consumer Affairs for a pre-notice review. So I'm pleased to report that Michael has made significant progress over the last few months on a lot of these regulatory packages. So basic life support equivalency standards have been approved by the board at the November 2017 meeting. He has completed the initial rulemaking documents, and those have been submitted to Spencer, and Spencer's been reviewing those to get those ready to submit to DCA. Our continuing education requirements are going to be discussed by the board during tomorrow's meeting. The dental assistant comprehensive rulemaking, I reported to the Dental Assistant Council, is expected to be brought forward to the DAC at the May meeting for them to begin considering and make further recommendations as to whether or not move it to the full board to initiate a rulemaking. Determination of radiographs and placement of interim therapeutic restorations has been submitted to board legal counsel. Spencer's in the process of reviewing those documents, as well as the elective facial cosmetic surgery permit applications and the mobile and portable dental clinic and unit registration requirements. Citation and fine requirements were approved by the board in August 2017. Those were approved by legal counsel and were submitted to the Department of Consumer Affairs on January 22nd, and we're waiting for it to go through that review process. The minimum standards for infection control are also in the process of being drafted by Michael. I know a few versions have gone back and forth with Spencer, but Michael's taking another crack at it. So I'm hopeful Spencer's he's very, very quick at turning these around. So I'm hopeful that we'll have these all submitted to the department within the next month or so.
Okay, any questions?
Comment.
Yes.
This whole process remains confusing to me, and I do think. Oh, thank you. I do think that I've seen a couple of pages laid out where this process is identified, because you just identified it goes through 3 or 4 steps, and we have newer members on this board, so I know I'm not the only one that would like to maybe see that review again. Do you think that we could have that at a future meeting?
Yes.
I think it might be helpful. Thank you.
Just to further comment on that, yes, we can go through the process, and I think it's important for board members to be somewhat familiar with it. But I think what the board members should be most familiar with is the topic we're talking about, and when the language comes before the board, to understand what the language is going to do. Once it's approved, then it goes off into this never land that we're trying to reduce the time that it takes to get a regulation processed and through the system. So yes, Dr. Stewart, I believe we can show you what the process is, but I would suggest that board members, once the language is approved, will give you updates on where it is in the process, but that you don't really have to bog yourselves down with understanding it more than essentially when the language is published, it goes through a number of a period of time where people can comment. All the comments are brought back to the board. The board hears those comments, decides how they want to move forward. It goes back out for comment, and so that can go back and forth and back and forth. But we haven't had something in that process for a while now. So as we get them launched into the process, we'll be happy to walk that through. So yes, we can give a general explanation of how the process goes, but I think that up until this point, most board members are understanding what the issues are that we're getting clarification for with the language, and certainly as we bring these forward, please ask. There's a number of things we're going to be talking about at this meeting, and so that might be also a time. Okay.
talk a little bit, but do talk a little bit about the Office of Administrative Law's clock there, when times that they will receive, and how we're working to try to change that.
Yeah, you want me to talk about that now?
Just a general.
And I'm not sure that I'm following you in terms of what do you mean we're trying to change that?
That they were only receiving packets at certain times, at certain quarters, and we're trying to work to get that change so that the department speeds up their process.
Can we delay this for a future meeting?
Yeah.
Okay. Thank you.
Okay.
So, just to preface, the next 3 agenda items are all initiations of rulemakings. And so this is the very first step in the process. Well, it's like the next to the first step in the rulemaking process. So typically in the rulemaking process, you have preliminary rulemaking activities where you're identifying the need to promulgate a regulation. It may be a result similar to what we've done with the dental assisting regs, where we've had stakeholder meetings. Sometimes there's legislation that make it very evident what the changes need to be, and sometimes there's staff recommendations that come down as a result of workload and our regs are just out of date and we need to update them. So it can come from a variety of areas. And so the next 3 agenda items are this. And so the preliminary rulemaking activities for these 3 agenda items was very short because it's a result of various topics. But the first one, agenda item 10B, is discussion and possible action to initiate rulemaking to amend California Code of Regulations Title 16, Sections 1019 and 1020 relating to substantial relationship criteria and criteria for evaluating rehabilitation. This is a result of legislation. AB 2138 was signed into law last fall. Currently, the board may deny or discipline a license based upon discipline imposed by another state, an agency of the federal government, or another country for any act substantially related to the licensed profession. AB 2138 requires the boards to amend their existing regulations governing substantially related crimes or acts and the rehabilitation criteria. Business and Professions Code Section 480 currently authorizes boards to deny an application for licensure based on a conviction for a crime or act substantially related to that profession. Additionally, Section 490 authorizes the board to suspend or revoke a license on that same basis. AB 2138, which was the legislation just recently passed, specifies that the 3 criteria that boards must consider when evaluating whether a crime is substantially related to the regulated business profession, and that the criteria must include the nature and gravity of the offense, the number of years elapsed since the date of the offense, and number 3, the nature and duties of the profession in which the applicant seeks licensure or in which the licensee is licensed. And so today we're bringing forward proposed regulations to change what our substantial relationship criteria is and to further define the criteria for evaluating rehabilitation. AB 2138 requirements become effective July 1st of 2020. To get through the rulemaking process, we need to begin today. And so, Spencer, jump in at any time. Spencer Spencer assisted us in putting this proposed language together, and maybe he could walk us through why we need to do this.
I will do that. If the board members would take a look at proposed regulatory changes, the language that is underlined is new language that will be added to both sections 1019 and 1020. The board or board staff did not come up with this on its own. What I and board staff had to do was to take a look at the statute and as well as the all-agency memo that the department's chief counsel sent out to assist the boards in crafting regulatory changes. So the language that is stricken is language that is removed in order for the amendments to comply with the new legislation. So in section 1019, as you see, minor changes were made to subdivision A as well as B and C. And does anyone have any questions with respect to that language? Because again, this makes it consistent with the legislation. And with respect to section 1020, subdivision B contains language that is new, which is underlined again, and language that is stricken for the purposes of this amendment, as well as the legislation. If you look at C1, the legislation refers to crimes rather than offenses, so that is why offense was stricken. And again, in C3, the same thing, offense was stricken and crime was added. And with respect to C6, evidence of dismissal. The legislation does not mention expungement, so again, to make it consistent, dismissal was added. And that is it for the proposed changes. Does anyone have any questions with respect to 1019 or 1020?
So board staff is requesting that, and I'm going to read the motion, and that we're requesting, to make it easy, that the board approve the proposed regulatory language relative to substantial relationship criteria and criteria for evaluating rehabilitation, and direct staff to take all steps necessary to initiate the formal rulemaking process, including noticing the proposed language for 45-day public comment, setting the proposed language for a public hearing, and delegating authority to the executive officer to make any technical or non-substantive changes to the regulatory package. If after the close of the 45-day public comment period and public regulatory hearing, no adverse comments are received, delegate authority to the executive officer to make any technical or non-substantive changes to the proposed regulations before completing the rulemaking process, and adopt the proposed amendments to California Code of Regulations, Title 16, Section 1019 and 1020 as noticed in the proposed text.
And the motion would be to approve the proposed regulatory changes and to adopt the staff's recommendation. Someone can say so moved, unless you have
Move.
something.
So moved.
Who second? Who seconded?
Why don't you make
Open for discussion.
any discussion? Any public comment? I'm going to call for the vote.
Okay. And the motion's to adopt the staff recommendations on item B. Burton?
Yes.
Burton, aye. Chan, aye. Chappelle Ingram?
Aye.
Chappelle Ingram, aye. Lai? Yes. Lai, aye. Laren? Aye. Laren, yes. Lay?
Aye.
Lay, aye. Mackenzie?
Yes.
Mackenzie, yes. Medina?
Yes.
Medina, yes. Morrow?
Aye.
Morrow, aye. Alagi?
Yes.
Alagi, yes. Pacheco?
Yes.
Pacheco, yes. Stewart?
Yes.
Stewart, yes. Witcher?
Yes.
Witcher, yes. You?
Yes.
Yes. You. Passes.
So again, this is, Dr. Stewart, this is the beginning of the regulatory process. And it was generated because of legislation. So we'll report back on the progress.
So the next step will be staff will notice the rulemaking, which means that it's a certain document that is prepared that indicates what the board proposes to do. And it will be noticed for 45 days for folks to comment on it. And if they do make comments that are related to it, sometimes comments are made that really have nothing to do with the proposal. So then those comments are rejected. But if they are clear and they relate to the proposal, those comments will have to come back to the board for consideration. And assuming things go well, it'll get through the department, it will be filed with the Office of Administrative Law, and they have 30 days in which to approve, in which to review it. If they find no concerns, it can take up to a year for the rulemaking to be approved. But if there are some serious concerns, let's say someone commented on the language and the comment so it makes sense, which would require for the language to come back before the board to possibly make amendments to it. And if that occurs, then it will go out for another 15 days for public comment. But if it changes the proposal in any regard, then it could possibly have to go out for another 45 days. So this process can be very lengthy. It'll come back to the board through having to renotice it. So that's why it can take up to a year. And sometimes commenters can, let's say, why is this an A1 instead of, why don't you just make this B? Well, that quite possibly could occur, but that would be a non-substantive changes, and based on the motion of the board delegating the authority to the executive officer to make non-substantive changes, staff can go ahead and make it a B without having that to come back before the board or requiring it to be posted again for noticing. And once it is approved, well, let's say that Office of Administrative Law says, we don't agree with this. So we are going to issue a decision of disapproval, which means you will have to start over and address the concerns, which means, again, once those changes are made, the Office of Administrative Law would have another 30 days in which to review it, and it could take up to another year. So it's just a convoluted process, and I believe that, Karen, I understand why you didn't really want to go through that right now, because unless you are involved with the process, such as board staff is, it's something that it can take time to learn, a great deal of time to learn. So it would just confuse you. It would absolutely confuse you.
But what we want to tell you too is once it goes out for the 45-day comment period and we get comments back, the board staff works with legal to evaluate the comments and bring to the board not only the comments, but a recommendation of whether to accept or deny the comments, and then why we would be doing that. So we'll be watching this one to see sort of as an example of how it's going to move through the process.
I think for new members, one of the important things to take away from this is that a bill becomes law, but that's only the beginning of what has to happen. You've got to go through this very long regulatory process, and sometimes depending on whether people are agreed or disagreed with the piece of legislation, it can be arduous.
So I guess we're ready for the vote.
So,
Oh, you voted. You already voted on B. You passed it.
okay. So we
On
voted
C.
on B, so now we're going to go to C, item C.
So this is the second regulatory proposal that board staff is bringing forward to the board for consideration. The board has a legislative mandate to establish a diversion program, which is a confidential program that permits licensed dentists and allied dental health professionals who meet specific eligibility criteria the opportunity to recover without the loss of a license to practice their profession. Through the diversion program, the board can closely monitor the recovery progress of known chemically impaired licensees, which enhances the board's mission to provide consumer protection. The board is authorized in statute to establish a diversion evaluation committee. And the board has current regulations that establish two such committees, a Northern Diversion Evaluation Committee and a Southern Diversion Evaluation Committee, and specifies that each of these committees consists of 6 members, consisting specifically of 3 licensed dentists, 1 licensed dental auxiliary, 1 public member, and 1 licensed physician or psychologist. And that these committees assist the board in evaluation of licensees who may be impaired due to the abuse of drugs or alcohol. Pursuant to the board's current regulations, the membership of these committees are limited to serving 4-year terms, and they're limited to serving only 2 4-year terms. What has been happening is with the Diversion Evaluation Committee, we are limited in our candidate pool for those committee members that are qualified to participate as a Diversion Evaluation Committee member and make recommendations pursuant to the board's regulations. So board staff is recommending that we amend our regulations to delete the requirement for one of the members to be a licensed dental auxiliary and increase the public membership requirement to 2 members, which would broaden our candidate pool for available members. And we also recommend amending the regulations to delete the limit for the DEC members to only serve 2 4-year terms. This would allow the members to serve at the board's pleasure without specifying a term limit. So if we had a qualified Diversion Evaluation Committee member that wanted to serve for life and they were doing a good job, we wouldn't be limited in our candidate pool to have a less qualified person be able to participate.
Diversion Evaluation Committee members are active participants in the diversion program. They monitor the participants, and the participants come in on a scheduled basis before this committee, and they talk about their progress in recovery. Most of the evaluation committee are prior participants in the diversion program, so they truly understand not only the issues of alcohol and drug abuse, but they can tell when somebody's lying. They've been there. They know what's going on. They're very valuable people, but we don't have a lot of people like that out there. The reason we're asking for the dental auxiliary to come off is that we don't have any dental auxiliaries who have the time, who can get away from the office to participate in this process. And we rarely have, I'm close to saying never, but we rarely have RDAs or EFs in the program because they can't afford it. So their participation isn't necessary. So again, the composition, we would like to see the board decide to go to 2 public members. That gives us more flexibility for the candidate pool. And really, if we could alleviate this idea that they can only serve 2 4-year terms. You all heard the testimony of Dr. Curtis Vixie, who's been involved with our program for a long time. He essentially then would be allowed to continue, and his experience and expertise in this area, I think, are unmatched. And so for us to lose somebody like Dr. Vixie and the other people who have been in that committee, I think would be tragic. So that's a little more explanation of why. Now, jumping back to the process, this request is staff-driven. So there's a number of ways that regulations come before the board. You've seen now an example of legislative mandate. Now this is coming before the board because the staff believes our current regulations need to be updated.
Dr. Stewart.
Through the chair, I'd like to move that motion.
That would be to approve the proposed language and to accept the staff recommendation. Yes.
Second.
Second, Morrow.
Actually, Mackenzie.
Oh, Mackenzie.
Mackenzie.
Oh, I'm sorry, I didn't hear you.
It's fine.
Are there any questions?
I do.
Okay.
President. With regarding the 3 licensed dentists, and some of the concerns from the last presentation that they brought forward was expenses and so forth. Is there any way we can also find a way to involve dental assistants in this? Because the dentists will have a budget range. I'm not saying that we should do that, but I'm just looking at considerations because dentists might earn a little bit more than the dental assistants that were unfortunately not able to afford this program. So maybe having their input on what can better help them as well might help with the increase of dental assistants participating in the diversion program.
I think Ms. Fisher said for dental assistants, we have very few who actually go through this program because of the expense of this
Right.
program.
Yeah.
And there is some expense required. And also, for them, it's very difficult to get the time off to meet.
So yeah, that's
So I-
to my point.
Are we not hearing we may not be understanding your question.
So the question would be, in the 3 part of the committee or the members of the committee, there's 3 licensed dentists, 2 public members, and 1 licensed physician. So from the last presentation that they brought forward was those 2 issues that Ms. Fran mentioned as well. And having 3 dentists, licensed dentists, don't necessarily represent other groups that might be not taking advantage of the program. Am I still not clarifying?
Okay, so we're talking about the composition of the
committee.
evaluation committee.
Right.
And the reason we recommended that 1 licensed dental auxiliary be taken off is because for years we haven't had any candidates come forward to say that they would want to be on the committee because they typically can't take the time off of work to participate.
Okay.
So
So
So-
the committee here is only evaluating patients that
people in the
in the
program.
program, not necessarily looking at the way the program is being managed.
I'm thinking your question is probably different, but I'm not quite sure how to.
What do you mean by managed?
So the thing is that my concern is making sure that more of the dental assistants are participating because of the costs, and
Okay.
yeah. And
Okay.
so the thing is that when
Okay.
you don't have representation within the committee, then no one's really looking at the issues of why they're not really participating. And so
I see.
I
Okay.
don't,
Okay.
So we can agendize for a future
Okay.
meeting talking about ways in which to be able to have RDAs and EF participate in the diversion program. I think that's where you're going
right.
with that.
But then, so the committee, that's what I was trying to understand. The committee is not looking at that. They're just looking at
Right.
direct with the doctors that are referred to the program or
Right.
patients. Okay.
That's correct.
Excuse me, I have a question. Can a dental auxiliary be a public member?
Yeah.
Yeah.
Can they count?
Yes.
They can just go in as the public member.
Yes.
So that could be a way to possibly incorporate them.
Sorry for the confusion.
Okay, we have a motion, a second. Are there any other questions? Is there public testimony?
Claudia Pohl, CDAA. While we have no problem with the term limit elimination, we would prefer to see the dental assistant or dental auxiliary committee person left on because removing it removes that possibility of them being represented. So that would be our input.
How long has it been since we've been able?
Well, I don't think it actually does remove it. It removes the classification, but they could be appointed as a public member. So the flexibility is still there. And we're actually, the reason why we recommend them be off is that we have nobody apply for the position. And even if they applied, they'd have to show that they've had experience within addiction, alcohol, and drug treatment. So it's almost as if we're putting them on there, but at this point we're recognizing nobody's able to meet those requirements. So if at some point, and regulations can be changed down the road if we have the data to show that it should be changed. Right now, we have the data that shows no RDAs have been in the program for over 7 years. We don't anticipate that there is going to be anybody getting into the program. So therefore, and thirdly, we don't have people applying to the diversion program. So, I mean, we have 3 solid data sets right there. If something changes, we do have the flexibility at this point to put somebody into that public position. And at some point, if we see that RDAs and ES are going into the program, then certainly the regulations can come back before the board and that can be changed. So we do have the flexibility to be able to do that.
A couple questions. If memory serves me correct, they do not have to be
You
through
have
the
to speak up a
diversion.
little or move the microphone closer.
A committee member does not have to go through the diversion. They just have to be familiar with.
Right.
Okay, so it does not require them going through the DEC program.
Right, it does not require it. The DEC actually does the interviewing.
Right.
And with their number of years of experience in this process, I mean, it's difficult, it would be difficult to, I mean, the current Diversion Evaluation Committee would do a thorough vetting of whoever would be interested in serving.
Understood. But it doesn't require having
No,
gone through
it
the
doesn't
program.
require having had previous experience on our deck.
And what has board or staff done to put out and solicit an
We've had a
auxiliary on the
recruitment
deck?
notice on our website homepage for 3 years, 4 years.
But most auxiliaries aren't on the web page. Is there anything else that's been done to try to recruit?
You're now aware if you'd like to recruit within your organization.
I do post. I do, when I'm aware, I put it out there, but
Yeah.
I didn't know if the board has done something to recruit
Well,
auxiliaries.
we've put out a recruitment notice on our homepage, of the board's homepage, and it's been posted there for a number of years now.
Yvette has a question.
With respect to the no-term limits, are these 4-year terms renewable? Are they just no term limits, period?
They'd be serving at the will of the board.
Okay.
Or until they resign.
Anything else? No other public comment, call for the vote.
Somebody might not understand that.
Okay. Burton?
Yes.
Burton, aye. Chan, aye. Chappelle Ingram?
Yes.
Chappelle Ingram, yes.
Oh, yes.
Sorry.
I'm sorry. So much for your repeating it. You want to start again?
Okay, so let's start again. Burton?
Yes.
Burton, yes. Chan, yes. Chappelle Ingram?
Yes.
Chappelle Ingram, yes. Lai?
Yes.
Lai, yes. Laren?
Yes.
Laren, yes. Lay?
Yes.
Lay, yes. Mackenzie?
Yes.
Mackenzie, yes. Medina?
Yes.
Medina, yes. Morrow?
Yes.
Morrow, yes. Alagi?
Yes.
Alagi, yes. Pacheco?
Yes.
Pacheco, yes. Stewart?
Yes.
Stewart, yes. Witcher?
Yes.
Witcher, yes. You?
Yes.
Yes. You? I got it.
Get your rhythm.
I got my rhythm.
Okay, that takes them to item D.
So item D is a rulemaking relating to the passing score for the dentistry law and ethics examination. This was based on a recommendation made from the Office of Professional Examination Services. As we all know, we conducted our occupational analysis of the dentistry profession this last year, and as a result of completing that occupational analysis, we're working with the Office of Professional Examination Services to update the board's California Dentistry Law and Ethics examination to make sure that it's up to date and in compliance with our psychometric requirements in Business and Professions Code Section 139. Through their review, the OPES has recommended that the board not specify the passing score in regulations. So current regulations, I believe it's Section 1031, specify that a candidate shall have been deemed to have passed the examination if his or her score is at least 75% in each examination. So after talking to OPES, they recommend that a criterion referenced passing score, which applies standards for competent practice to all candidates regardless of the form of the examination administered, be implemented rather than implemented in regulation. So the criterion reference passing score increases the likelihood that candidates who pass the licensure examination have sufficient knowledge and experience to practice safely and competently. OPES follows a criterion reference methodology called modified Angoff technique for determining licensure examination passing scores. Standard setting is a group process. The group is composed of licensed practitioners representing all aspects of practice or profession and a test development specialist. And so how we do this is we recruit subject matter experts, and they participate in workshops that are administered and coordinated by the Office of Professional Examination Services. They put together testing questions and set the passing score. Criterion reference standard setting begins with the establishment of a minimally acceptable level of competence for safe practice that candidates must possess in order to pass the examination. So the group develops the common definitions of the different levels of a candidate's performance by identifying critical work behaviors that contrast the highly competent, the minimally competent, and the incompetent candidate. So because licensing examinations are known to vary in difficulty from one examination form to another, a fixed passing score or a percentage such as 70% does not represent the minimally acceptable competence for all administrations of an examination. And therefore, arbitrary passing scores are not considered legally defensible. So at this point, the board is recommending that we amend our current regulations for the dentistry law and ethics examination in Section 1031 to delete the requirement for the passing score to be at least 75% in accordance with the OPES recommendation.
McKenzie, sorry.
So just specifically on the language that we have here, I would probably add, whether it could be in the preamble there, that successfully complete with a passing score, because I wouldn't want someone to argue that they successfully completed it just by finishing the exam.
So where would that change?
You could do it, you could say prior to issuance of a license, an applicant shall successfully complete, and you could put there either with a passing score, or you could put it at the end, successfully complete supplemental written examinations in California law and ethics, comma, with a passing score. Either one, I don't know if you guys care.
It's a good point.
Or successfully pass, but I want something about passing in there, so even if we don't have a set 75%, that it's not just that they literally finished the exam.
Does that work, Spencer?
That'll work. No, it will work.
You don't have to decide.
Would you
And
recommend
so we all
replacing-
agree that it's comma with a passing score? That will be the new language?
So it would be a candidate shall be deemed to have passed the examination with a passing score? Is that?
No.
What'd
So
you-
I'm looking at the proposed language.
She's looking at this.
So am I looking at the wrong thing?
Issuance of a
Oh, you're looking at
license.
the top.
Mhm.
Yeah.
Okay. Let's see.
So
Because if we delete C, there's no other reference to passing.
So prior to the issuance of a license, an applicant shall successfully complete supplemental written examinations in California law and ethics. New text would be comma with a passing score, period.
Right.
Okay. That works for me.
That's a good point.
Say that again. I'm sorry.
So existing text, prior to issuance of a license, comma, an applicant shall successfully complete supplemental written examinations in California law and ethics. New text would be comma with a passing score, period.
So it's here.
Okay.
Here.
Excuse me, isn't it an assumption that successfully completing is a passing score? I mean, I'm not opposed to specifying with a passing score, but what does successfully complete mean?
Someone could argue that they successfully completed it by finishing the exam.
Yeah.
Well,
I
they
completed the
it, but
exam,
not
and it was
successfully.
well.
Okay. Yeah, I
I've
mean-
argued over less.
Right.
so-
I mean, I'm not opposed to it. It seems like it's emphasizing the obvious, but
It very well could be, but but I've seen enough language disputed that
Sure.
I want to make it clear that we're not getting rid of the concept that you still need to pass.
right.
It's not that you just have to finish. You know.
I agree.
Shall achieve a passing score.
Okay.
That would be good too.
Written examination in California law.
Okay. We have
Shall achieve, yeah.
Yeah.
that
we
works.
have a plan C.
Perfect. I think I
Right.
heard it, but yeah.
Prior to issuance of a license, an applicant shall achieve a passing score on the supplemental written examinations in California law and ethics.
Perfect.
Does that open the question of, then what is that passing score?
No, because we can still determine that.
You can still.
Yeah, that'll be
And that's the whole point of this whole thing. Well, I don't know that Dr. Stewart is finished.
It just seemed like OPS is telling us that it's, we can't attach a number. I don't know what they would, how they would define passing.
So each examination, through a process, the passing score may flux. And that's why you don't want to have a specific number.
Sorry.
So each examination by the Angoff scoring system allows the examination to be scored in a way to determine what the passing score is based on the candidates who took it. So it could conceivably be a little higher or perhaps be a little lower, but it still would be considered a passing score.
So if you go back to page 2, the third paragraph, I think that kind of,
I'm sorry, Fran, would you?
if you look at page 2, the third paragraph, okay.
I understand why OPS believes this is not defensible, but I have to at least comment that it sounds like doublespeak. And the doublespeak is that we can allow them to take the test, and the object was you were counseled on what ethics and the law was. And then if they transgress it, you took the test. You said you passed it. But now we're saying it's okay. You don't have to. If they make a transgression and you took the test, it's almost telling it's okay. You don't have to pass the thing. It's a doublespeak. It's a doublespeak.
There's still a passing score. It's just that the passing score fluctuates depending on the difficulty of the questions, and the number of difficult questions.
I understand that reasoning, but I think it's still doublespeak. Wrong is wrong here, but if the scoring changes, wrong is not here.
No, but
No, the scoring
the
changes.
scoring may change, so it's still
Okay.
right.
Okay, but so So my assumption is, so the difference is not from the same exam from one day to another. If you gave the exact same exam all year, then whatever is considered passing is the same. The difference is if next year you don't want to have the exact same questions because maybe you think the questions are out there or people know what they are, you want to vary the questions a little bit, and then you look at them and you're like, oh yeah, these, we came up with harder questions. So if you have really hard questions, then maybe you show sufficient knowledge by 65%. If you have easy questions, maybe you need to show 90%. So that's why that's I think what this is trying to get at is that not that if we took the exact same exam, there would be different passing scores like this month versus next month. It's just that different exams might have different passing scores to still show that we're competent.
Okay, anything else?
I understand.
I just have to say for Dr. Lai.
Yes. You didn't have to. That's okay. Thank you. I appreciate that. I think the number confuses me as well. You should be ethical and law-abiding. There should be no discrepancy or moving average. That's just my comment.
Well, we have a couple of options. If you still aren't understanding this, I suppose there could be a motion to delay this. I wouldn't recommend that at this point because we have had the Office of Professional Examinations say that currently they don't believe our method is legally defensible. So that's why I would hesitate holding this off any longer, though that would be an option. If you would like the staff to contact OPES and have them come to a future meeting to explain what all this means, in addition to moving this forward, that's an option. But I think at this point, what our subject matter experts are saying, and that's the Office of Professional Examination, they're recommending that we delete this line in our regulations. They are tasked with making sure that our examinations are legally defensible, psychometrically sound and legally defensible. So I think that we need to trust their judgment. But if you need, if you feel you need further education on this whole methodology and the ANGOF workshops, that's something that we can agendize for a future meeting.
Before we do that, I'm going to democratically test this, and I am going to move that we accept this language.
I second Yvette Chappelle.
As amended, as amended.
As amended.
So move Burton, second Chappelle Ingram.
And could you read the language again, Spencer?
Yes, I will. Prior to issuance of a license, an applicant shall achieve a passing score on the supplemental written examinations in California law and ethics.
Okay, it's been properly moved and seconded. Any questions?
I want to speak in favor of the motion.
Okay.
I accept that the people at OPES are much more knowledgeable about examination, construction, and assessment of knowledge from an examination, and I accept the fact that they accept my expertise in dentistry, and as a result, I agree with the motion, and I encourage us to put ourselves in the good hands of the OPES people and make sure that our examination administration is defensible.
Well stated. The experts.
Well stated.
Dr. Lay.
Just for clarification, this only applies to the dentist license, correct?
To the what?
To only the dentist, just the dentist applicant, because the RDA exam is already a combined exam.
Yes.
So it's not separate. So this is only applying to the dental candidates.
This regulatory package is only applicable to the dentistry law and
Correct.
ethics
Okay,
exam.
I just wanted that clarification. Okay, thank you.
Any other questions? Any public comment? Call for the vote.
Okay. Burton.
Aye.
Burton, aye. Chan, reluctantly, aye. Chappelle Ingram. Chappelle Ingram, aye. Lai.
No.
Lai, no. Laren.
Yes.
Laren, yes. Lay. Lay, aye. Mackenzie.
Yes.
Mackenzie, yes. Medina.
Yes.
Medina, yes. Morrow.
Aye.
Morrow, yes. Alagi.
Yes.
Alagi, yes. Pacheco.
Yes.
Pacheco, yes. Stewart.
Yes.
Stewart, yes. Witcher.
Yes.
Witcher, yes. You.
Yes.
You, yes. Motion passes.
Thank you. Okay, I'm sorry.
Once this regulatory proposal is noticed on the website, the language that you will see relating to that, the first sentence, will include new underlined language, and the language that is will not be included will be stricken. So it will not look like this.
Okay, with that, we are going to recess into closed session for the day.